Welcome to today's program titled Legal Considerations for Employing Minors. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ariel Fenster. Ariel, please go ahead.
Thank you, Donna, and thank you everyone for joining us today. My name is Ariel Fenster. I am a senior associate in the Atlanta office, and I primarily practice in the Department of Labor investigation space and day-to-day wage hour counseling with a significant focus on child labor laws. I'm joined by my colleague, Scott Hecker, who is a senior counsel in the Washington, D.C. office, and he brings considerable experience having worked in the Department of Labor in both the OSHA division and the wage hour division, both of which, as Scott will mention in our forthcoming webinar, have significant initiatives regarding child labor laws. And so we're excited you all could join us today on this very timely topic as we're heading into the summer months and we know we see an increase in child labor. On the next slide, we will go over our overview for today and the topics we'll be talking about. First, we'll be talking about onboarding minor employees in different employment laws we should think about that aren't necessarily specific to child labor law, but are important if you do have minors in the workplace. We'll talk about FLSA notice requirements, working hour restrictions that are specific to having minors in the workplace. There are state-specific nuances depending on where you operate, the current government initiatives in enforcement and exposure, which you're lucky enough to have an expert from the Department of Labor here, and then we'll open it up for questions. If you have any questions, as Donna mentioned, while the presentation is going on, feel free to drop them in the chat box and we'll try to answer them as we go, depending on who's speaking. But if we can't get to them, we'll try to answer them at the end or circle back with you after the presentation is over. So let's get to it and talk about onboarding minor employees. So on the next slide, as I mentioned, we'll start to begin to talk about what laws are most important. But I saw this quote that was issued by the Equal Employment Opportunity Commission Bulletin, and it's almost kind of an oxymoron, but it says the youth is the most vulnerable population with respect to employment laws, and they're often targeted, but they also fail to follow the laws. So I found this interesting because what the EEOC was saying in the article is that minors are often targeted because they don't understand employment laws. So on one side of the coin, you know, the EEOC and different government agencies feel like managers or business owners are taking, you know, advantage of minors and making them work long hours and, you know, enforcing certain laws upon them that might not actually be the actual laws. But on the same side of the, or on the opposite side of the coin rather, they're actually failing to follow the laws because they don't understand them. And so you kind of have two issues. One is that, you know, the government thinks we're exploiting minors, but on the same, you know, on the opposite side, they also, you know, are failing to follow the laws, certainly because they just, you know, don't have the experience to work places like those probably on the call do, and so they're creating exposure and liability as well. And then on the next slide, I'll kind of talk about some of these laws that aren't specific to minors, but certainly rub against them. And one of those that made me think of this presentation was conviction questions and ban the box. And there's no specific rules that say we can't ask minors questions. In fact, it's, you know, statewide about any employees. But this issue came up that I had with a client the other day, which is that while working for our client, an individual was convicted of an indecency of child laws. And it was interesting because they couldn't ask certain questions related to ban the box or convictions, but it placed a concern because they had minors working on site where this manager was. So it really made me start to think we really want to, push the limits to some extent when we do have minors in the workplace about what questions we're asking about criminal history. We certainly want to be compliant with ban the box and asking, only what we're allowed to on applications and with continued employment, but we do need to be extra careful when we have minors that we're creating a safe environment in a workplace. So if you do have minors, I'd certainly recommend that you reach out to legal counsel and make sure that you are complying with very heavily regulated ban the box laws, but certainly creating a safe workplace for your minors as well. Another topic that's important is really onboarding and training your minors. As I mentioned, most of these people that are minors in the workplace, this might be their first job and probably is their first job. And so they're going to need a certain level of training and understanding about what may be basic rules to you and I, like timekeeping or taking your meal break or taking your rest break, because they oftentimes just don't understand the importance of it and the liability it creates for us as employers or HR supervisors or managers. And so training our employees oftentimes for minors might be a different training or might be, extra training that might be specific to minors to really drill down and make sure that they understand employment rules and the implications that it can cause, which is just not something we all think about as minors. And then another topic that's important if you have minors in the workplace is sexual harassment and reporting procedures. I read several articles in preparing for this, and I've seen it run true in my practice, is that minors are actually the most common that are sexually harassed in the workplace. And we wouldn't think of that because, oftentimes our clients don't even have minors. And so it's really important that we have multiple avenues for reporting and also that the minors have good training on what to do if they do have a sexual harassment occur in the workplace. And that certainly includes having people other than their manager to report to. And I'd recommend that they have several reporting avenues because as minors, we have to kind of get into that mindset, but it would probably be more uncomfortable for them than other individuals in the workplace to report that type of behavior. So important things to think about that might not be on the horizon if you're just Googling like minor labor laws or child employment laws. On the next slide is another topic that arises in the workplace as well when we have minors is whether we should classify them as intern. Traditionally, this might be more in a college education setting, but we have seen it in high school settings, particularly where clients or interns rather have like a dual immersion program or they're doing something with kind of a local community college and also working in high school. And so oftentimes our clients will come to us and say, well, this is an individual who might be getting academic credit, or I think I could label this an internship. So we need to really analyze whether we're saying that because they're a minor, or are we saying that because this is truly an internship by the definitions of employment law. So the first question that we should always ask ourselves, is this a job that would otherwise be filled by an employee? And if the answer is yes, you would have a regular employee, regardless of their age, fill that job, then that job should probably be a regular W-2 compensated employment position. Now, if this is a job that you're truly creating an internship program for, then we can start to begin to analyze whether it's truly an internship under the Department of Labor factors or under the different tests that various circuits have held. One thing that comes up as well when we have internships is unique pay structures. So we will have different clients come to us and say, well, I will pay them on a stipend, or can I pay them on a weekly rate as opposed to an hourly rate? And oftentimes we can facilitate those types of pay structures, but it's important to think about if the goal is to pay them minimum wage and to pay them overtime, to make sure that those stipends or weekly rates account for that. And if they don't, then there might be an argument that we can pay them less than minimum wage if it's a true internship. And the way that we look at that is, one, if educational credit is being given, that's often a very good test that this may fall as a true internship in the eyes of the Department of Labor. If educational credit is not being given, most circuits look at this as whether or not, who's the primary beneficiary. Is the employer the primary beneficiary? If so, probably not an internship, and internship for purposes of, minimum wage standards. And then also the Department of Labor has a 7-factor test that they look at, which essentially goes through a primary beneficiary test and looks at who's really benefiting from the internship itself. Now, if they don't meet those primary beneficiary tests or the Department of Labor 7-factor test, then we really need to accommodate wage hour laws such as minimum wage, meal and rest breaks, and all the other, tangential wage hour laws that flow from that. So certainly something to think about if you're having minors in the workplace and considering paying them under what you consider to be an internship program. On the next slide, I believe I hand it back to my colleague, Scott Hecker.
Yep. Thanks, Ariel. So I wanted to talk a little bit about what we're calling FLSA notice requirements. If we go to the next slide, you'll see that might be a little too narrow of a title for this section. We really want to talk about some of the best practices that DOL recommends to employers. Of course, there are notice requirements under the FLSA, and we have this fancy, unreadable example of the poster template that is required of employers to post in the workplace. Another fact sheet that you might find helpful is actually fact sheet number 43, available through the Wage and Hour Division's website. Has a lot of information about some of the laws and also common issues that people come across when employing minors in their workplaces. But listed here are again those 7 best practices for employers that I mentioned. These are also available on DOL's website. They talk about the importance of training, not only, as Ariel mentioned, kind of from the minor's perspective, but training your supervisors and managers on child labor requirements and really how minor employees may come with some different issues in the workplace. So you should be aware of those issues that can arise for young workers. Distributing resources. Again, this could be a form of notice. I might suggest that there could be publications available. There's a young worker toolkit available on DOL's website as well that can give you an idea of what DOL again is looking at. And we always find it important to think about what the relevant enforcement agencies, what they're putting out there and how they're approaching these issues so that you can evaluate exposure with a little bit of a flavor from their perspective. Building trust, you see there, again, I think this goes back to what Ariel was saying about if in the unfortunate situation, harassment occurs or some other issue with a minor worker, they'll need, some avenues, plural, to report those kinds of issues. And you can do that, a lot of times. I also work in the occupational safety and health space, and a lot of times you'll see that there are internal avenues, anonymous phone lines for reporting, for example, safety issues. You could do something similar as an employer employing minors so that they have somewhere to report anonymously so that there's less of a chilling effect and folks would be more willing to speak up potentially. Providing different name tags. I defer to some of our EEOC colleagues on how much you can do that. But I think we crossed some of those issues actually with COVID about vaccination status. So you want to definitely figure out whether that raises any issues, but it's something that DOL suggests is, having a different color badge for folks who may be minor employees so that you're aware of who those folks are and what kind of additional issues, for example, hours restrictions may be applicable to those people in those employees in your workforce. Posting warnings. So hours limitations, again, you can put something up like fact sheet 43. Again, we're focused here on non-agricultural occupations. I will say there are some different things. So if you're in the agricultural space, you may want to follow up or take a look at some of those different resources. But fact sheet 43 will address non-agricultural issues and really provide you a lot of information that, again, could serve as a poster, a publication, something to distribute to your workforce, both minors and older folks, to be aware of the issues at play here. Signage, something you could put on a equipment that maybe 14, 15-year-olds or even 16 and 17-year-olds, if it's hazardous occupation coverage, that they would know not to go and work around this machine or on this machine. And similarly, the spotlighting hazards, you could include a stop sticker, something like that on equipment that DOL considers dangerous and hazardous. And there are hazardous occupation orders that the Wage and Hour Division has issued. And just a note on that, sometimes it's interesting to think that hazardous occupations would fall under Wage and Hours jurisdiction. OSHA's take is frequently, you'll hear OSHA say, well, our laws, our regs apply to everybody. And it just turns out that Wage and Hour under the Fair Labor Standards Act has gotten responsibility over child labor issues. That's not to say that if Wage and Hour shows up to do a child labor related investigation at your work site, you won't hear from other folks like OSHA. We've seen a ton, I would say, of press releases recently where there's a Wage and Hour announcement of penalties and it notes an OSHA investigation is ongoing, or there's an OSHA announcement of penalties and a Wage and Hour investigation is ongoing. So it seems pretty clear that the agencies are speaking to one another, likely making referrals between one another. And it's certainly a whole of government effort at this point. So something to be aware of. Wage and Hour has primary responsibility, but if there are safety issues, they may not only apply to your minor workers, and you could get a visit from OSHA as well, as these agencies continue to chat about these concerns. And I think we're going back to Ariel to dig in a little bit more on the working hours restrictions that we've alluded to.
I'm on mute. Okay, on the next slide, we'll talk a little bit about the working hours restrictions. So generally speaking, the most restrictive laws are related to children in the workplace that are ages 14 through 15. That being said, there are state law nuances that go up to 16 and 17 as well. But federal laws only apply to 14 and 15-year-old children and the timing of where they work. So there's some kind of, questions that have been in the chat now about state law nuances, and there are states that are more restrictive, and now there are states, as Scott will mention, that are pulling things back a little bit. But generally speaking, for federal laws, if you have 14 or 15-year-olds in the workplace, they can't work more than 3 hours on a school day. And sometimes that can be a little bit confusing when you're relying upon children or even their parents rather to relay when the school day working calendars are. And we've seen that happen when there are children who are going to schools in different counties, or we have children in private schools, how that school day aspect can lead to a management confusion. And then the other rule is that there's no more than 8 hours on a non-school day. Similarly, if you don't know if the school is a school day or a non-school day, that can lend to some confusion as well to how many hours they can be working. And then no more than 18 hours cumulative per week during school, and no more than 40 hours per week when school is not in session. And then there are also some start and stop time limitations as well, 7 a.m. to 7 p.m. So outside of those hours, you cannot be working. And then when school is out of session, they pull that back to 9 p.m. And as Scott mentioned, we're not talking specifically about agriculture and farming on this. And if you are one of our clients that are joining us for that, certainly reach out after. But there are different rules and restrictions for those in the industry as well. And on the next slide, I believe I hand it back to Scott to talk. And I know there have been questions, as I mentioned, about state-specific nuances. So Scott will answer those questions. Answer those now.
Yeah, thanks, Ariel. So, states all have their own child labor laws, and some, are more restrictive than the federal rules, and some have been moving in a different direction recently. I would say, I think Ariel referenced meal and rest breaks. That is something that we've seen states have stricter rules on those kinds of providing those. And also there are record keeping provisions that, relate to making sure you do start and stop times for those meals and start and stop times for the workday. You just heard Ariel talk about the restrictions on work hours, and it seems a lot of states want to see that you're really following those. And so they have stricter, even if they don't require older workers to clock in, clock out, beginning and end of shift, beginning and end of break or meal, they will have that requirement for employers to maintain records regarding child labor. So you want to pay attention to those state-specific rules on record keeping, meal, rest breaks, for example. Several states have, like I said, been loosening restrictions on, in particular, hours, but that's not the only change that we're seeing. And you'll hear sort of the drumbeat is it's a tight labor market. This is more people to get into the economy, and you're giving opportunities to younger workers for experience and personal growth, those kinds of things to getting them in the workplace. We've seen publicly reported numbers that suggest 16 or so states have bills that would loosen child labor laws. And then on the flip side, a slightly lower number, around 13, are looking to strengthen them. And we've seen recent examples in Arkansas in March of 2023. Governor Sanders signed a law removing requirements that the state verify ages of workers under 16 and provide them with work certificates. That's something that has gone away. Very recently, May 7th, just a week ago, the Missouri House passed a proposal to eliminate work permit requirements for underage workers. And there's a similar bill in Alabama that's waiting for the governor's signature there. Wisconsin's governor actually recently vetoed a similar bill. So you see it again. These are coming, similar laws are coming, bubbling up. Sometimes they make it through, sometimes they don't. Other states have had bills that look to let 16 and 17-year-olds work construction jobs. That was a Minnesota proposal to extend the school night cutoff, for example, from 9 p.m. for 14 and 15-year-olds, to 9 p.m. for 14 and 15-year-olds in Ohio, or to follow Arkansas in eliminating the work permit requirements for some minors. Georgia is one of the states who's done that. And even a state like New Jersey amended their laws to let younger employees work longer hours during the summer. And New Jersey and others have moved away again from requiring those age certificates for minor employees. And that's a little bit tricky, I would say, for employers. There are provisions in DOL's regulations that speak to sort of having an age verification, an age certificate, providing a shield to that employer to say, hey, look, we have this. It was approved by the approving federal or state agency. And so we can rely on it. You can't come after us. We did what we were supposed to do. The federal government has not been doing those for a while. They have not removed it from their regulations, so it's still in there. And then as we see, some states are retreating from that too. So it puts employers in a bit of a bind to ensure that they're doing their due diligence and confirming appropriately that the folks who are presenting their age documents, birth certificate, license, whatever it is, are actually presenting legitimate documents. So that is a tough one. Some other states, again, all work hours restrictions were removed for 16 and 17-year-olds in Indiana. That in the past, they couldn't work past 10 p.m. or before 6 a.m. on school days. That's gone. It also extends legal hours for 14 and 15-year-olds. And Florida also recently rolled back hours restrictions for 16 and 17-year-olds and had at least considered making some changes to work restrictions regarding residential construction. Iowa is one that has drawn perhaps the most publicity just because it's probably the most permissive in loosening its restrictions. Iowa expanded minors' hours, let minors work in some manufacturing plants, and allowed minors to serve alcohol with a parent's permission at certain ages. And actually, a state senator from Iowa reached out to the Solicitor of Labor, Seema Nanda, and the administrator for the Wage and Hour Division, Jessica Lumen. And they wrote back saying on August 24th, in a letter on August 24th, 2023, that provisions of Iowa's child labor law appear to be inconsistent with federal child labor law. And employers covered by the FLSA who only follow a less restrictive Iowa law will be in violation of federal law. So you really have to pay attention to some of these more permissive frameworks, whether it's hours or hazardous occupations or other child labor related obligations, because even if you seem to be complying with your state, those federal regulations really serve as a floor. And so if you are violating the federal floor by being more permissive under the state reg, you could wind up with a Wage and Hour Division investigation by the U.S. Department of Labor even if your state agency is not, is going to allow the practice to occur. So it's federalism is wonderful. And so, you have to pay attention to all these different things if you operate in multiple jurisdictions. Just giving one example of a child labor law that is looking to be potentially stricter. Colorado is currently looking to increase potential penalties and also encourage minors to report violations by prohibiting retaliation for such reports, by eliminating criminal liability for minor employees' parents or guardians under Colorado law, and by publishing companies' violations. So if you get a final order, sometimes we refer to that as public shaming, but you can expect a press release, and that's in an effort, obviously, to not only increase minors' efforts or others, their coworkers' efforts to report violations. It could also be designed to deter other folks from employing minors and sort of suffering the same fate through those kinds of violations. So I think we are back to Ariel to move into the government initiatives, enforcement, and exposure section.
Ariel, you're on mute.
Thought I would have learned last time. Okay, on the next slide, we'll talk about why this is more important than ever and what the initiatives the Department of Labor has issued. So February 2023, approximately a year ago, the Department of Labor partnered with HHS to come out with an initiative to say that they're focusing and cracking down essentially on child labor law violations. And what that means is they're hoping to investigate more companies and really scope out the lay of the land and correct any minor violations that they believe are occurring. So following that, in November 2023, they started issuing, which Scott will go over, field assistant bulletins, revising and articulating the way that they're going to penalize companies to reduce what they believe will be minor child labor law violations in businesses. And there's frequent press, regarding investigatory findings and consent judgments. And what all this means is that, we have the Department of Labor now, if you are employing minors, more on your backs than ever. And though, they're kind of down in investigators now and really trying to pump that back up, this is certainly a focus for them and something that they are wanting to publicize and wanting to show as a positive, good initiative for them that they're, fixing the workplace with respect to minors. And so Scott and I, over the last few months, have seen quite an uptick in child labor law, Department of Labor investigations, more than ever. And then, as Scott will go over, there's an increase in the civil money penalties. And so this is really becoming a hot press topic for them as well. And they're continuing to introduce bills to strengthen child labor law protections and penalties. And this is a real focus for them. And so it's more important than ever to really tighten up when you do have minors in the workplace to potentially avoid larger penalties than before, but also just this negative press, as you can imagine, that goes on with, XYZ companies, struck with $1 million for a child labor law violation. It just hits a little bit different than, some of the other employment law headings that you may see, as you can imagine. So I'll hand it back to Scott to talk more about those field assistant bulletins and those civil money penalty increases after I go over Department of Labor investigations. So one thing that we are seeing, and so oftentimes clients will come to both Scott and I and say, I'm a little bit confused. I don't think a minor is going to sue me. And so as we've been mentioning through this, where the fines and the civil money penalties are really being enforced through Department of Labor investigations. There's not necessarily damages that you're going to get through violating child labor laws. I say that with the caveat that you can certainly have overtime or off the clock or meal and rest break violations that apply to everyone and could also apply to minors. But the most common avenue that we're seeing these child labor law violations are through Department of Labor investigations, which Scott and I spend considerable time helping our clients with. And one of the very first questions that gets asked, regardless of whether the Department of Labor investigator knows or not, is if minors are in the workplace. That's just a preemptive question they ask right when they get to the work site. And if they are, they almost immediately ask you to begin to show proof, show the IDs you have on file. If you have those age certificates, show those. and then also begin to show their schedules so that they can begin to assess as a Department of Labor investigator whether those federal and state laws from a timing perspective have been met. And so there's just this increased scrutiny if you do have minors in your workplace, if a Department of Labor investigation happens. And just because you have minors, it doesn't mean that, there was a minor complaint that happened or that the investigator is necessarily focused on the child labor law. But it's certainly going to be something that they're going to really run through and check all the schedules and check all the time and pay records. So you really want to make sure that that's tightened. And we have, worked through many, many, many Department of Labor investigations, and certainly see the importance of having an attorney help guide you through that. From a, business disruption, we can help reduce that and reduce usually the records that are being requested, and certainly have many times, if not most often, helped reduce what the exposure and the penalties are. But when you do have minors in the workplace, it just increases the possibility of exposure and penalties. And now I will hand it back to Scott to talk about what those penalties are.
Thank you. I'm going to talk a little bit about why there's such a focus by the department on this. And there are a number of stats that you'll see cited publicly in media, on DOL's website, and just pointing to increases in child labor violations in recent years. You'll see there the third box suggesting that the number of kids employed illegally in the last 5 years is up 88%. In fiscal year 2023, 5,800 kids employed in violation of child labor laws, according to DOL. DOL also has suggested it has 800 open child labor cases right now. And so these numbers are all on the up. There's a bit of a chicken and egg here, I would say, probably. Once you start looking for it, you're going to find more. So is it really happening more, or are we just paying more attention? I'm sure it's a little bit of both. And these issues kind of came to the fore when kids were found working in hazardous conditions, and understandably there was a reaction to that. So when we first kind of saw the whole of government effort that we referenced earlier, beginning in February 2023 with DOL's strategic partnership with HHS, and it was designed to target and reduce child labor problems. Again, we know that wage and hour is really the primary enforcer under DOL. But you also see outside the executive branch, Congress looking at legislative options here. A lot of times they may focus on increasing penalties. You'll see the argument that it's just a cost of doing business to pay for these violations, and it's just easier to pay them than to go through the upfront effort to ensure compliance on the front end. Obviously, we would always counsel compliance and recommend compliance, and it's important to know on the front, how you protect this workforce subset, and keeping ahead of the potential for increases in penalties and those kinds of things will obviously help limit your exposure. But there are a number of bills pending currently, not a ton of traction from what we can tell in this sort of divided Congress. But the House and Senate have both had hearings regarding exploitive child labor practices, sort of different approaches. Some look more to the southern border and increased immigration of younger and younger folks that contribute to the problem potentially, because those vulnerable workers may be more susceptible to trafficking and issues like that. So that's something certainly Congress has been paying attention to. But in the end, the sort of the collaboration between these agencies is certainly designed to share information, to increase awareness, and to combat these issues. We've talked before in blog posts or on webinars about the historically low numbers of actually investigators at the Wage and Hour Division, which certainly can hinder enforcement efforts, even for the grandest of priorities. And that is something that Acting Secretary Sue has been stumping in congressional hearings for, suggesting if Congress wants increased enforcement efforts in these and other spaces. They need to fund it. Remains to be seen how that will go over. And we also talked about how the federal government enforcement needs to be balanced against the states, and to see where the federal government can focus. If it feels like a state like Iowa is doing more harm than good, maybe it sends more folks and more resources out there. So it's important to evaluate those state rules for that reason too, to determine what your exposure might look like under the federal rules. If we go to the next slide, we'll just have sort of a snapshot of what enforcement efforts have looked like. The number of cases with child labor violations in recent years, you can see generally on the upswing there. The employment of minors has gone up a fair amount over the last couple years. You can see a little bit of a reduction in hazardous occupations, which may be too early to know whether it's from this enforcement effort, but a move in the right direction, presumably. And then you'll see the numbers, even where those hazardous occupation violations are going down, you'll see that the assessment numbers, the civil money penalties out there are on the rise. And those are going to continue to go up from what Ariel and I can tell, based on some of the client activity we've seen, and how wage and hour is approaching these things. And part of that comes from, if you look at the next slide, the fact that DOL, the Wage and Hour Division, has updated its assessment procedures for non-serious injury and non-injury child labor civil money penalties calculations. So now it's based on instance rather than based on child. So it's a per violation basis, which, as you can imagine, increases exposure because as DOL provided an example, if you have 3 separate violations relative to one child's employment, there's maybe 2 hazardous occupation orders and 1 record-keeping violation, the employer now will be assessed 3 civil money penalties. So, and each of those could be at the statutory maximum. So that's rather than the 1 that you might have gotten before for that 1 child, now you're tripling your exposure. And the CMPs currently are $15,138 for each child labor violation. So you can consider, if you have multiple kids, unfortunately working in hazardous occupations or working outside work restriction hours, then you can see those things jump. And there's a gravity calculation to that, where aggravating or mitigating factors are considered. There's also business size and the objectives of the FLSA factored in. That seems a little squishy, the objectives of the FLSA, but they are certainly designed to protect workers, and you could see that being construed pretty liberally in determining what your final assessment might be. The other piece that you can see that might be a big issue here. Actually, you know what? I think the other piece that we might want to look at is actually on the next slide to speak about another focus in the child labor space, and that is hot goods, which are goods produced in an establishment in or about which, always good written language, oppressive child labor occurred. And so what I think is interesting in particular there, what we've seen as something interesting there is you could see where you might have someone working, for example, and this is an example that was given in this field assistance bulletin number 3, 2023-3, that if a company sends a miner to perform landscaping work outside a clothing company's factory, where goods turned out to have been produced and eventually shipped in interstate commerce, and then the miner is using a power-driven saw to cut wood, which would fall under a hazardous occupation order, that would constitute oppressive child labor. And even if the miner is not engaged in commerce or production of the goods that will be shipped in commerce, the hot goods section for child labor could still apply to the factory where those goods were produced. And so even if the miner is employed by the other company, the landscaping company, not the clothing company, and the landscaping company isn't actually engaged in interstate commerce, it still could be that the goods produced at the clothing factory removed from the establishment within 30 days of the miner using that power driven saw, that could be considered hot goods and therefore could be barred from shipment. Obviously, that's a big impact, depending on what kind, they reference a clothing store, but you can consider if you had perishable goods and something similar happened, what that might do to your supply, and how it might impact the supply chain. And this kind of, I would say, there's sort of, I don't know, whiffs of joint employment there. And I think you can see that DOL is really ramping up its efforts to hold the entire supply chain accountable in these circumstances, to leverage the economic piece and the economic effects of child labor violations to the best of DOL's ability. They like to use the phrase "every tool in the toolkit," and you can see where you're ramping up the instance by instance per violation CMPs, or you're broadening the scope, at least in the implementation of your regulations, to capture more employers in the hot goods net. All of these things are going to be, affecting the bottom line of businesses. And we had a podcast a while back with Neil Giles from Stop the Traffic. It's publicly available on our website. And he suggested just that one thing he thinks will really make a difference is making the violations impact the bottom line. And that didn't just involve exposure, but it also he raised the issue of, thinking through some of the potential issues you could identify by taking a look at your subcontractor's proposed contract costs. And if they say we have a crew of this many people doing this many hours of work and it'll cost, this amount, and that amount's not possible based on, minimum wage requirements, there could be something exploitive going on in the supply chain with your sub. So these are kinds of things, goes back to the training we talked about. That's something HR or accounting or finance or whomever, your operations folks, all need to be aware of these kinds of things to minimize risk. One other thing to note, though, in the hot goods space is the potential for a good faith defense. There is an allowable good faith defense here, so it's something to pay attention to when you're working with other contractors, vendors, et cetera. Purchasers of goods can show that they relied on a written assurance from the producer, manufacturer, dealer of the goods that they were produced in compliance with the requirements of the hot goods provision, and that they acquired such goods for value without notice of any violation. So it's a case-specific analysis, of course, as many things are, and it requires the purchaser's objectively reasonable knowledge or belief that the assurance of compliance was true, and that the purchaser wasn't aware of any other child labor violations. So you can't claim it if you acquired the goods after becoming aware of a child labor violation. You didn't receive actual written assurance. It needs to be in writing beforehand. You received the written assurance of compliance after acquiring the goods. It's not going to work. You need to get that ahead of time. And you need to rely on that written assurance with respect to the future production of goods rather than addressing, again, goods already produced. So DOL is really looking at the fact that you made the effort ahead of time to ensure that you were working with an above board vendor who is willing to make that written representation that they have produced their goods, manufactured their goods in compliance with the relevant FLSA provisions. So with that, I will take a breath and go to the next slide to share our CLE code for the day. We do, as Donna mentioned earlier, have this scanning QR option here. I will also read SS as in Seyfarth Shaw 6287. Again, that is SS as in Seyfarth Shaw 6287. That's the CLE code for today. You can go through the scan, or I believe Donna said in the invite materials, there will be a CLE form you can click through. And also, I think after the fact, we will, as I believe was answered in the questions, be providing the deck after the fact. And so you'll be able to view that and click through there as well to do CLE if the scanning doesn't work. For me, I'm not from the future, so I usually do it through clicking links. But we do have some more time. If anyone has additional questions, or Ariel, if you have any additional thoughts to share, we can certainly do that.
Thanks, Scott. I think I did answer most, if not all, questions that came up. Most of the questions were related to kind of state law nuances. And as we mentioned, most of the state law nuances are, related to 16 and 17-year-olds with start and stop times and meal and rest break requirements. And, our firm and our really wonderful survey center has, if you're a client of ours, surveys for child labor laws that Scott and I oversee. But, the information is also, widely disseminated on the internet as well. But if you have any other questions, please let us know.
Yeah, I would just echo that. If there are state-specific questions, a lot of this can be regulatory intense, just to find the right rules and how and where they apply. So especially where the shift is going on, where it seems like at least more than half the states are considering some sort of action, whether making it more strict or less strict. It's something to stay on top of, particularly where you are coming up, as Ariel mentioned right at the top of the presentation, on potentially ramping up retail or other, summer intense occupations. I'm seeing a few more questions come in. Okay, I'll grab the last one first, just because it's the one I saw. What triggers the DOL looking at a work site for child labor law violations? So yeah, DOL is always going to tell you they will come to a work site. Wage and Hour will come to a work site for two main reasons, and that's either a complaint or an initiative-driven sort of programmatic inspection, that they have a particular focus on areas, or industries that they've seen an uptick in violations. So here, we just said retail, hospitality, things like that could be industries where there are a number of minor workers, and that could be an area where DOL would endeavor to perform programmatic inspections, not in response to a complaint. But the other way it comes through would be if someone, picked up the phone or shot an email or whatever it was, walked into their local Wage and Hour Division office and said, hey, I know that there's an 8-year-old doing hazardous work at a nearby, whatever, fill in the blank. And that could also lead to an investigation based on child labor issues. So those are the kinds of reasons underlying them, and Wage and Hour is not going to tell you typically that why they are there. In part, as you can imagine, it's so that the employer is not guessing at who the whistleblower is, and so that there's no retaliation. Again, DOL doesn't want chilling effects on potential complainants, because they do want to have the opportunity to investigate if there are allegations and to see whether those are valid. And so those are typically the reasons you're going to see someone from Wage Hour show up at your door. And that's not just for child labor violations. Those are the ways that all of them start. And as Ariel said, everyone is going to have the question, if you have workers under 18, or 19, give us the paperwork on their date of birth.
And to that point, Scott, I would add, while they have these initiatives related to child labor laws, they also have industry-specific initiatives as well. Last year, they had an industry-specific initiative for fast food workers. And so I personally had an influx of individual franchisors and franchisees, and they were very focused on child labor law violations. And we've also seen, an influx in the agricultural and farming industry as well this year. So sometimes, it is mission driven and industry specific driven. And then also, as you can imagine, most often we're not having, a 14 or 15-year-old actually calling the Department of Labor, but I've seen many times where the complaint comes in from a parent, maybe like a child isn't doing that well in school, and it's because they're working late, and then they start to do a little research on the internet, or a friend gives them the Department of Labor number. So usually, just like as you can suspect, oftentimes the complaints don't actually come from the minors themselves. Scott, there was a specific question. I think you had mentioned Indiana kind of restricting or moving some of their hours restrictions, and somebody was asking for some
Yeah,
follow-up.
I do believe that is what I said. So they were repealed work hours for 16 and 17-year-olds. Previously, those ages couldn't work past 10 or before 6. And it did also extend hours for 14 and 15-year-olds. And similarly, I think I followed it up with Florida is in a similar boat, and other states are in similar boats. New Jersey, others, are just kind of loosening up the limitations on hours. So I think there was another question about if you're 16, how late can you work? Unfortunately, I think we often have to give the lawyerly answer of it depends. I believe, Ariel, it would be 9 p.m. or 7 p.m. or 9 p.m. In certain situations federally, but it could differ in particular states.
Yeah, we'd have to look at the state-specific guidelines, and then it also depends, obviously, if they're in school or not in school. So it depends is the answer, but also check, the specific states where you have those individuals. And then we have another question about if the student has graduated but is still 17 years old. I get this question a lot. So the minor violations still apply to them, but whether they're in school or out of school will differ. So oftentimes a Department of Labor investigator will come in and they'll say, well, this individual is 17, so they're in school, so this law applies. And that's at a time when you can correct them and actually say, no, actually this individual has graduated, so the out of school rules apply. But the minor laws still apply to them. It's just that kind of in school versus out of school. There are a few states which have actually specific rules that say if you're graduated, then these rules don't apply. So again, answer depends, but you have to check your state specific nuances for that.
And Ariel, I'll ask a clarifying question there just so I understand.
Yeah.
So if you say out of school, if you've graduated, that would mean school out of session, you could work until, for example, under the federal rules, 9 p.m. rather than 7 p.m. Is that right?
Yes, as long as you've graduated, then you're out of school because you're not in school anymore. And then, as I mentioned, there are some states, and I don't know them off the top of my head, that will say, this rule applies to you if you're 18 and under and still in school. So check your state specific nuances for that, because sometimes it will have like a little caveat in the rule itself.
And I don't know if you've come across this. I haven't specifically. I saw a couple questions about homeschooling or school hours. I think as the employer, you should either document what your students' school hours are, or what lacking that, potentially like what the local school district's typical hours are. And I think for homeschooling, I wouldn't try and get too cute with it. I would treat it the same. I would say, the local school is 8 to 3:30. And so that's probably what DOL is gonna say. Even if you're not physically in the school. I'm sure there are requirements for homeschooling from the Board of Education, local education boards about what kind of criteria you need to meet for homeschooling to be permitted. And so I would imagine these same kinds of rules would apply to the homeschool situation. And I would just kind of try and educate myself on what the local hours typically are.
Yeah, you're exactly right, Scott. We shouldn't get too cute for homeschool rules. We have to kind of apply the same rules, because oftentimes the laws will just say if school is in session. So even if your homeschool schedule, because you're just educating one child or a group of children, sometimes those homeschool schedules are reduced. They're still in school, so we follow the school rules. I've seen, a lot of employers have difficulty with the fact that they're, especially in the franchise and fast food world, they're employing a lot of minors. And so they have people from different school districts, and they have people from private schools and home schools. I've even had situations where employers are like on a bordering state, and they have people coming in from other states, and that becomes really confusing because now you have different states. And it really is quite burdensome for a manager at, maybe even like a junior manager, somebody at an elementary kind of manager level, to collect all of these school schedules and be the responsibility holder as to whether or not somebody's in school or out in school. And that's why it's so often we're relying upon minors to tell us, are you in school or out of school? And then we're employing minors sometimes who just want to help out their family and want to work more hours. So they say, oh, I'm actually not in school today, or I got out of school early, or it's a holiday, or, fall break and spring break and all these different breaks. And so oftentimes it's really out of the goodness of, somebody's heart that they want to work more. And then a manager just being overwhelmed and relying upon that. So I really feel for a lot of these employers who are just trying to do the best managing so many different school schedules.
Yeah, no doubt. It's a lot, and there are certainly particular considerations across different industries. I know someone was asking about hotel industry. You may not have the issues that you would have um, in a grocery store. In a hotel, you may be more paying attention to the work restriction hours wise, as opposed to hazardous occupation issues. Someone asked about the hazardous occupations or what hazards may be. Again, OSHA is going to define a hazard under its regulations all sorts of ways. There are many, many, many hazards memorialized in OSHA regulations. But when it comes to child labor, particularly, there are hazardous occupation orders in the regulations at 29 CFR. That's the Code of Federal Regulations 570.50. They start there and they sort of go from there, and it'll say what those prohibited hazardous occupations are for children, so that you can get a sense of what kind of activities are prohibited for minor workers, and what wage and hour might look to if it's doing a child labor investigation as something that's a hazardous occupation that could result in these kinds of civil money penalties that we were talking about earlier.
And one thing I think about as we begin to wrap this up, and Scott, I'm sure you've heard this too, is a lot of times when we have Department of Labor investigations and a client gets child labor law violations, they'll say to me, and I'm sure they say to you, Scott, at the end, well, I'm just not going to employ minors anymore, and that will resolve the problem. And maybe that does work for your business, but as we've seen kind of wages increase, it doesn't always work for all of our clients' business or the type of industry we're in. Obviously, if we're in a summer camp industry, that's just not going to be as much of an option as it might be in other clients. But what I will say is I've seen this happen more frequently with an attempt to kind of reduce hiring minors maybe at the 14 and 15 age level. We've seen a greater increase in, fabricated identifications because these minors want to work. And that's, as Scott has mentioned, those age verification procedures are really important. But I've seen that come up with several clients more recently, is an attempt to not hire minors sometimes will result in people just producing, for lack of a better word, fake identifications to work.
Right. Yeah, for sure. There's a couple more questions that just came in too. I think, Ariel, you mentioned the survey center,
Yes.
which should have state-by-state information available. I think portions are publicly available, but you may need to be engaged with us to access certain more nuanced surveys. Is that accurate?
Yeah, I'm not sure exactly. I know if you're a client, regardless of what level of client you are, you have access to our survey center, and there is a survey which we keep up to date that Scott and I are in charge of that really goes through the nuances of minor laws. I'm not sure if it's publicly available to our non-clients. I don't think it is.
Yeah,
but,
I think you're right. It's client access. So we do have one. Connect with us if we can be helpful there. And then restrictions regarding, questions regarding age restrictions running afoul of state protections. How to best navigate those state challenges where the employer doesn't have a legal basis for the limitations, but a business decision. I mean, as long as your business is operating legally, I don't know if you're asking are there equal protection laws that might require you to consider minor workers. I think, Ariel, maybe you were just getting at that with, well, I'm just not going to hire minors.
Yeah.
But we are practicing more in the workplace safety and workplace, wage and hour space. So some of those other EEO type, equal employment type questions, we can certainly support and look to our subject matter expert colleagues on. I don't have an answer off the top of my head on those kinds of restrictions, though. As long as you're making legal business decisions, I think reasonable limitations that are compliant with relevant law should be okay. I don't think you have to provide minors with employment. But, you know, if you open it up, you may need to think about whether any restrictions you place on particular subsets of your workforce are complying with the law more generally.
So I think
yeah.
the last question is just related to union efforts by minors. I personally haven't seen that. I don't know if you have, Scott, but neither of us profess to be labor law attorneys.
Yeah, I do not do traditional labor work, and I have not seen that. I have not heard about that, though it's certainly possible. One more time, I will, even though Donna said I couldn't repeat this, and it is in the chat. The code was SS 6287, SS 6287. We're at the top of the hour. We appreciate everyone's participation and active questioning. And thanks for listening. Please reach out if you have any questions. I think our emails have been on the screen for about 15 minutes, so hopefully you had an opportunity to jot it down. But thank you very much, Ariel. Thanks. Always a pleasure to present with you.
Thanks, everyone. Thanks, Scott.